who is our new chairperson designee. And we welcome her, and we're happy to have her with us. And therefore, send it to you.
Thank you. This thing is on and you can all hear me, right? Okay. Good afternoon. My name is Alex Fisher. I am the chairperson designee of the New York City Loft Board. I would like to welcome you to our October 24th, 2014 public meeting. Minutes. We will first turn to a vote on the minutes from the September 18th, 2014 public meeting.
Are there any questions or comments about the minutes? No. Okay. Anybody have a motion? Ms. Shelton. Anybody second? Mr. Delaney. Ms. Watt, would you hold the board, please?
Mr. Barowitz?
Yes.
Mrs. Kurtzman?
Yes.
Mrs. Fisher? Chairperson?
I'm abstaining.
Mr. Delaney?
Yes.
Mr. Foggin?
Abstain.
Mr. Schachter?
Yes.
Mrs. Shelton?
Yes.
Give us the totals in a second. Five and two.
5 yeses and 2 abstain. 1 absent.
Moving on to the executive director's report. Maggie Alexander, our executive director, will now give her report.
Good afternoon, everybody. I really have very little to report today because I've sent you the statistics, and I think they're fairly self-explanatory. And I hope that they informed you and that there was enough context so that you could to get everything that you needed to get out of them. Mr. Delaney, you'll note that I put in all the units, the number of units for each building for you as you requested.
Yes, thank you.
You're welcome. And that's about all that I have to say. In the agenda, we have, following my very limited comments, we were going to have a conversation about the legislative initiative. And we are still going to have that. But Ms. Shelton has to leave early today. So if there is no objection, I would like to move the cases up on the agenda and take care of those first, so that she can be voting on those with us. And then we will finish up with the legislative conversation. Having no objection, we can now move to the cases. Okay?
There are 16
Oh, Mr. Delaney, I'm sorry.
Yes, I had requested that we revisit the website on the agenda, but since that's not, it doesn't need to be, I would like to, I remain appalled, I think would be a fair word. And I really want to see if we can get some commitment. I mean, there was a lot of nodding and agreeing that yes, all these things are a problem and you need help, but the Department of Buildings has a very nice website, and somehow somebody managed to post the first 2 video records of the, is it March and April meeting?
That was me. I did it.
Right. But then
There was only one other one, and that was me, and I did it, and it's posted. And it was posted within 72 hours onto YouTube. I wasn't able to get the link to put it onto our website, but it was put on the YouTube. But I just want to make something clear.
Sure.
I know that you wanted to talk about the website, and I would have put it on the agenda, but I truly believed that after I had emailed all of you and told you that we had a new person and that she and I had had the conversation and that she was going to bring this to DOB and advocate on our behalf, that it would not be necessary to make it an agenda item. But I am glad to hear you say in front of our new chairperson exactly what you've said. And let me just say that, you know, because it's good to come from more than one person, but I really do believe that the new chairperson is going to be able to get from our new commissioner that which you are talking about, which is to get technical help and expertise of those people at DOB who do the DOB website and do the DOB social media to do ours as well. And that would be a tremendous relief to me. And, you know, because, you know, I've been doing it, and I'm not equipped to do it, there's no question about it. So thank you, Mr. Delaney, and please don't think I was ignoring you, that's all.
Oh, no, but
I thought it was,
But
you understood.
I would point out that having dusted off local law 13 or whatever it is, or local law 103, it says the record has to be on the agency's website.
I know that.
Expecting people to go hunt it down on YouTube is not really logical, and we really need to be, I think, and I don't think it should be very difficult to be more, somebody needs to look at what needs to be done and then convey that to the technical people who can do it. But obviously, you know, the considerable number of things that are somewhat confusing, such as like the new starting time is 1 o'clock versus 2. It's just, it needs to be reviewed, and then it needs to be improved or made accurate.
You are absolutely right. We're on the same page, Mr. Delaney. Absolutely, all three of us, all of us.
Right, we were on the same page a month ago. No,
Yes, but you know, let me just say this, just so we're clear. After the last meeting, I started doing what I was supposed to do, which was finding a date for the next meeting, okay? During that time period, I find out that there's going to be a new deputy commissioner of legal and regulatory affairs. I don't know who it is, I don't know when that's happening, but I know I have to stop what I'm doing because something's going on, okay? So for that month, for that time period, this is what was going on. We were waiting to be told what was happening. You know, the commissioner's just come in, he's building his team, the law, while it's very important, is not, you know, the highest on his list. And so, you know, I'm doing the best I can to get all of these things before the commissioner and before Alex. This is going to be tremendous help to have Ms. Fisher with us.
Oh yeah,
Okay?
of that I have no doubt.
So, let's start from today and let's see how it works.
Well,
But we've been in 6 months of chaos because we did not have any of that.
Well, I would just offer one suggestion.
Yes.
Which is, if you sent me an email a couple weeks ago and said, hey, there's some things going on, I can't tell you what they are, but there's a reason I can't fix some stuff that you might have thought would otherwise have been fixed, that would have gone a long way to, I don't see the board as a group of people who get updated with a bunch of stuff the Friday before the meeting and then at the meeting. I think in a situation like this, there could be a little more.
I'm not even sure why you wouldn't have been able to say, we're waiting the imminent appointment of a new.
I didn't know if I was supposed to even know. You understand?
Okay.
I wasn't told until I was formally told. The day I was formally told, I told you. Okay?
So I would just add on to Chuck's comments that having the technical resources, I think it sounds like will be important for you, Lanny, but I mean, it will require obviously month-to-month attention in terms of updating the content. At least in the agencies I've worked in, the technical people just execute exactly what they're asked to execute and don't have the subject matter expertise to be able to weigh in on content. So I think it's both the technical, the expertise that allows it to happen, but also the prompting for it to happen on a month-to-month basis. So.
You ready for the cases now?
Sure.
Thank you. There There are 16 summary cases. These cases are voted on as they are.
You may.
Number 1, 240-242 LLC, 242 West 14th Street, LB 0186. Number 2, Lucien Harriot, 118 West 27th Street, TA-0199. Number 3, Michael Herman, 9 Great Jones Street, TR 0814. Number 4, Nicole C. Bouchard, Marta Nguyen, Julianne Nguyen, Bijou Nguyen, Jason Rohiff, and Genevieve Johnson, 151 Kent Avenue, Brooklyn, TR 0863. Number 5, Kimberly Levin, Kurt Fitzer, and John Tremblay, 235-241 Berry Street, Brooklyn, TR 0872. Number 6, William Brunder, 6 West 20th Street, TR 0886. Number 7, S. Max Miller and Carla Hokie Miller, 83 Leonard Street, TR 0962. Number 8, Matthew Green, Megan Slate, no address. Oh, sorry, so further names, Jeanette Gerard, Jacques Wolf, and Monica, I'm going to get it right, Switowska, 51-53 White Street, TR 1012. Number 9, Gary Campbell, 178 Walworth Street, Brooklyn, TR 1051. Number 10, Andre Gillardin, Michael Gelhardt, and Lori Gelhardt, 6 West 20th Street, TR 1067. Number 11, Eleanor Covan, 258 Bowery, TR 1095. Number 12, Carlin Brooks, 51-53 White Street, TR 1099. Number 13, Dominic Misperos and Jason Hugh, 100-110 Bridge Street, Brooklyn, TR 1110. Number 14, Michael Salas, 470 Flushing Avenue, Brooklyn, TR 1115. Number 15, Christopher Ivory and Paola Pineros, 470 Flushing Avenue, Brooklyn, TR 1182. 16, Richard Villard, 260 Moore Street, Brooklyn, TR 1200. Does anyone have any questions or comments about these cases?
I just wonder whether we need to read these all in front of this for the sake of time, since either we read these orders or we didn't read. Presumably we all read. So I don't know, just in the matter, since they're all voted on at once, I don't know whether we need to read them all off.
We've already done it for today, right?
Okay. Thank you.
This case that's number 2 this time around, Lucy Harriet, I had asked that that be tabled so we could take a look at whether there was a lease in effect, and I wonder if we got around to doing that.
Yes, the recollection is the questions were whether the building and the unit was registered, and they both are. And so,
And that person's taken off.
right, that was.
Okay, good, thanks.
On case 16, could someone just explain the backstory to me? Is it as simple as the owner registered the building and listed the applicant's apartment as a protected dwelling, and subsequently, perhaps unwittingly or unknowingly, the resident or the tenant in that unit filed for coverage, which was already, and so it's a lot of addresses to write on that application for nothing.
My guess is that this tenant became concerned about the incoming deadline, the statute of limitations for filing for coverage, and just wanted to.
An excess of caution, okay. I didn't understand there was something else there that we should be paying attention to. Thank you.
Any other questions? Is there a motion to accept the summary cases?
Mr. Foggin. Second.
Mr. Delaney? Please poll the board members.
Mr. Barwood? Mrs. Kurtzman?
Yes.
Chairperson? Mr. Delaney,
Yes.
Mr. Foggen,
Yes.
Mr. Shackman,
Yes.
Mrs. Shelton.
Yes.
7 yes, 1 absent.
Thank you, Swati.
We now come to the master cases. We have 5 master cases, 1 abandonment case, 2 coverage cases, and 2 removal cases. The first master case is Sheila Properties, Inc., 473-475 10th Avenue, Brooklyn, LD 0188. Ms. Cruz, would you please present this case?
On July 23rd of 2013, the owner of the building at 473-475 10th Avenue filed an application seeking a finding of abandonment for unit 503. The application alleged that Amanda Dunn abandoned the unit without paying rent or agreeing to a buyout. The owner listed the tenant as an affected party on the application and included 2 addresses for the tenant, the building's address and an address on East 64th Street. The tenant did not answer the application. On June 19th of 2014, Judge Miller issued a report in which she recommended that the Loft Board grant the abandonment application and declare the unit abandoned. The staff recommends that the board reject the recommendation. The record shows that in October of 2012, the tenant stopped paying rent and the owner started negotiating a sale of rights and improvements with the tenant. On June 28th of 2013, the tenant provided the building's managing agent a detailed list of the improvements that she intended to leave in the unit. On July 8th, the tenant vacated the unit allegedly without providing the owner with forwarding address and without agreeing to a sale of her Article 7 city rights. Pursuant to the Loft Board rules, an applicant is required to identify and serve all of the affected parties before filing an application with the Loft Board. In abandonment cases, the occupant alleged to have abandoned the unit is an affected party. Listing an affected party on an application as the owner to hear without including the party's correct address does not fulfill the notice and service provisions. In addition to listing the names of the affected parties, the owner must also make a diligent search for the tenant who allegedly abandoned the unit. It is the conduct of this particular person that forms the basis of this application, and the board's decision in the case will directly affect their occupancy rights. In this case, Judge Miller found that the owner made an affirmative effort to locate the tenant. However, the record does not support this conclusion. The only evidence regarding the search of tenant's current address is an affidavit by an owner's attorney, which says that the owner made affirmative efforts to locate the tenant and found an address on East 64th Street. However, the owner had noticed that the post office returned the correspondence that it mailed to the tenant at the East 64th address. Yet the record contains no description of what efforts the owner made then about finding that tenant's address and where the tenant worked. The simple assertion that the owner made affirmative efforts to locate the tenant without more does not satisfy the notice requirements. The staff recommends that the board reject Judge Miller's recommendation and dismiss the application.
Does anyone have any questions or comments about this case? Mr. Delaney?
What is the practical effect of this?
Of the dismissal,
Yeah.
the unit remains not regulated.
Pardon?
There's no effect, you don't get the effect of regulation, there's no abandonment finding.
Right.
I think that, tell me if I'm wrong, but you're asking what happens with this application, can they refile it with doing the due diligence?
That's part of my question, yeah.
The answer would be no, it's time barred.
It's now time barred. And we dismissed it without commenting on whether the dismissal was with or without prejudice.
We don't.
Any other questions, comments?
The address of the post office said was incorrect, was that the address of the tenant?
No. She had left no forwarding address.
I have nothing much to say about this, except that this case is very frustrating. I mean, this is the first time this has come up. And I just wonder whether there's some way that we can facilitate this, either by informing the owners of the lofts what due diligence requires, so we don't have to go through this rigmarole.
I believe that we've done that in several different cases where we've outlined the due diligence, and as a matter of fact, in, I think it's FD, we had a court of, the first department agree with us with regard to how much due diligence an owner must go through to find their tenant. In that case, the tenant was in California. We've done several cases recently, meaning in the last 3, 4, 5 years, where we have outlined what we believe due diligence is. And in fact, the courts generally have outlined it as well. I was surprised at Judge Miller because generally both, when they're on notice that the tenant has not received actual notice, will either really examine what the owner's attorney and the owner has done to find the person, and often has sent them back to do more due diligence to find the person. In this case, that did not happen.
Now, I don't remember, can we find the owner for not doing due diligence? I don't remember whether this would come up in our rules.
Can we find him? No, I think he's going to be punished enough.
Um,
He'll be punished enough.
Okay.
So before the tenant left, the tenant hadn't paid the rent for 10 months? Is that right, October through July?
Yes,
According to the owner.
according to the owner.
All right, well, the administrative, I mean, no, we don't have any facts to the contrary. I
No,
mean, we don't have anything from the tenant, so therefore,
right.
I mean, this is all according to the owner, right?
That's exactly right.
Okay. All right. Is there anything in particular that you find the owner being suspicious and we should disregard, or?
You're asking me?
Well, yeah, because you say according to the owner, I assume
Well, I'm reading-
everything we have here is from the owner, so therefore, that's like saying the case is from the owner.
Well, I was a little, we don't usually have a captioned area called factual background, but I found the first paragraph under factual background somewhat lacking in facts. And obviously, it sounds like there was, Mark had asked about the backstory of the previous case. It seems like there was a lot going on here, and to have somebody leave for reasons that aren't clear, who may have owed rent, probably did, for reasons that aren't clear, and then to have the owner immediately file for abandonment. Normally it takes a little while to get together. There must have been quite a lot going on here.
I don't know, that this is, I mean, there's a certain amount of, it seems to me that we have to accept a certain amount of assertions in order to consider these cases. I mean, I don't know whether the owner actually, killed and ate the tenant, but there's no basis to,
It's all here.
but there's no basis to presume that. So I mean, we're only dealing with the case at hand. So I guess what I'm trying to get a better sense from is the executive director, that she was surprised at the determination by the administrative judge, and I was just trying to get a sense of why we have sort of a gap in expectations, and which of course is a speculative question to some extent. But it seems to me that part of the idea, do you think that perhaps the administrative law judge felt that the discussions that took place prior to the tenant's departure sufficed to be considered adequate?
I can't tell you why she did what she did. And as a matter of fact, I can't tell you why any of them do what they do.
No, I understand.
But I can tell you that when I went back and I looked at other decisions, I had seen where, I mean, I was particularly troubled by the fact that Oath also sent a notice out to the tenant, and it came back with a similar postal message. And yet, that didn't even trigger Oath to the Oath judge to say to them, you know, this person is not getting their due process. What exactly did you do? Which has happened in a number of the other cases, and especially in the abandonment cases. So, do I think that somehow behind the scenes she found out more about the due diligence than she let on? No, I don't think so. Okay?
And people don't disappear unless they go into the witness protection.
She didn't disappear.
That's right, so,
She didn't disappear.
no, obviously you can't disappear in this society that easily.
Do we know where she is?
I mean,
No,
that makes it sound like.
excuse me, let me just say this. I can't, we shouldn't be going outside of the record. We're gonna have that conversation again in the next case. Okay, so let's have the vote and then I'll tell you. Okay?
Well, I would just, for anyone who's troubled, I would just note that in the final paragraph before the conclusion, we detail what would have been other steps that could have been taken that weren't taken. And the owner is represented by a very active attorney at the landlord bar, who surely is familiar with our holding in these cases. So, you know, the owner could have done more. And, you know, also, bear in mind, if I'm not mistaken, this is a very big building.
Yes, it is.
So if you're the owner and you have 88 regulated units or 89 regulated units, maybe it's like enough already. But he could have done more and he didn't do it. And his attorney certainly would have been able to advise him if needed.
The answer is yes, we could find her. We could find her very easily on social media. We could find her on Google. She was particularly well known. You know, in this day and age with the internet, with most of our people being...
So isn't it germane though to your
To me?
argument here in this case?
Well, yeah, but it's just outside the record, so you know, that shouldn't form my opinion. Yes, was I appalled? You bet. I was really appalled that, I mean, this woman was so easily found. You know, most of our tenants, a lot of our tenants are artists and performers. She's a performer. You know, so she was really easy, and so you know, they made a mistake. They did a bad thing.
I found her on Google. You know, so
There you
you're
go.
not always sure it's the same
Wait,
person.
It was.
As somebody who advocates that these proceedings be open to the public, I think we have to respect Lanny for warning us when we're headed outside
Yeah,
the
it's, you
record.
know, and you're going outside the record, but yes, you know, this did not inform my position. Okay, it had nothing to do with it. My position was based really on what I saw as affirmative steps and nothing more. And the fact that they knew that the letter came back and did nothing further, that was wrong. And that cannot happen. And this is the message to all of the attorneys that work in this area of law, that they must pay attention. They must give the people their opportunity for due process.
That's helpful, thank you.
Thank you.
Anyone else? Questions, comments? Is there a motion to accept this case? Mr. Hogan?
Second?
Second.
Mr. Barowitz. Thank you. Would you please poll the board?
Mr. Barowitz,
Yes.
Ms. Kurzman,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Foggen,
Yes.
Mr. Shack,
Yes.
Mrs. Shelton.
Yes.
That's 7 in favor and 1 absent.
Thank you. The second master case is a case that we voted on at our last meeting, which did not have a majority vote. It is Brian Coonan, Patrick Stetner, and Jennifer Cox, 140 Metropolitan Avenue, Brooklyn, TR 0948. Ms. Cruz, would you please present the coverage case?
Before Ms. Cruz does that, this is a case that we did last month. And if you've read it again, you've seen that we have not changed it, that we are reintroducing it to the board unchanged. So, you know, I'm not sure whether it would be helpful for you to hear Ms. Cruz again, and if so, you just say so. She's prepared to read the introduction again. But I have a few things that I need to say about this case. The first thing that I want to remind you all is that, that I have to remember what I wanted to say. Mr. Delaney asked us to look at, Mr. Delaney asked us to look at cases from the past. And the issue is whether we take all 6 of the units and make them IMDs, or we only take the 2 that were found to be IMDs, who still had active cases before oath. Remember, 2 people had never filed an application, and 2 people had withdrawn. Now, we did go back and we looked, and we found some cases. But it's still murky. There was not a clear, bright light that said, this is what the Loft Board always did. There were always, as with everything, it was sort of case specific. And in one case, the most recent case, the board voted to not bring that unit in. It was 333 Park Avenue, not bring the unit in, but with the caveat that that tenant, if there was a tenant in that unit that we didn't make an IMD, that tenant could apply later and wouldn't have to be put to their proofs. And that was okay because there was no statute of limitations. Okay, so we understand, and actually Mr. Delaney, in his concurring opinion, made that distinction. Okay, so, but it was not completely balanced in one way or the other. So again, we had 2 people who never applied. We had 2 people who withdrew. And why did they withdraw? Now again, I can have this conversation, but it is outside the record. One would imagine that they were possibly given remuneration to withdraw. That's certainly an option to consider. And that once they left, that the unit was not populated again as a residential unit. You also asked me to have somebody go and inspect the unit to see whether it was being used residentially, vacant, or used commercially. That also is outside the record. But we did that. And we found that indeed it is being occupied for commercial use. It is not residentially occupied. So having said all of those things, I want to say the third thing is that there is a due process component to this in that the owner was only on notice that he only had to defend on 2 cases, on the 2 cases that were before oath. He did not, or she, whoever it was, have to provide any defense on whether these were now actually IMD units or not. So those are the things that I have to say. Unfortunately, Leanne has had to leave, and I really needed her to vote because we have so few people. So do you want to hear the
Are you ready to vote?
Yeah.
Okay.
Are you ready to vote, or would you like to, or would you like to hear this? Because we need to have as many people as possible.
Is that a question?
Do you have any comments?
No.
Do you have anybody have comments or questions, Mr. Delaney?
I have the considerable amount of comments.
Ms. Shelton,
I got it.
she's got to go.
I'm sorry.
Would you like to leave your vote with us? Can we do that?
I don't,
Yes.
that's never been done.
I don't know what to do.
I'm sorry.
You can give her vote to somebody.
She can give her votes.
You give her vote
Daniel,
to somebody on the
yes.
board.
No,
Yes.
that's never been done.
Well,
Okay, let's
see. Anyway. Okay,
Well, she can't stay, so.
okay.
Okay,
She's
Mr.
left.
Delaney, what would you like to say?
Well, first I'd like to ask a procedural question so that we know in the future going forward. As you recall, at the last meeting, we weren't clear whether the vote was sufficient to carry. So I gather there has been a determination
I
made on that.
believe that I wrote to all of you, didn't I? And tell you that it did not carry because we didn't
No.
have half the majority.
No.
Doesn't sound
I think, yeah, I think you did.
get the answer, can I ask that you report to me what you determined?
What we determined? We determined that it was not a majority vote,
Right.
and it did not carry.
Because it was 4 affirmative votes?
It was the majority of the board.
It's majority of all 9 people.
Not just who's
Not just who's present.
quorum of who's present.
Or, because we've been through this in the past, or the number of seats that are filled.
Was there a determination about that? I mean, you know, generally speaking.
I'm asking about this only because
Sure.
it'd be nice to know so the next time it comes up, we're not reinventing the wheel or going in the
Right.
opposite direction.
But then, you know, the second question is, if it doesn't carry again, what in the world do we do?
Well, we have to get feedback from the board as to what it is in the
So
board.
there's a question on the table, which I'm actually quite interested in the answer to.
The question on the table is whether it's the majority of the entire board, not the majority of the quorum of who's present. It's the majority of the entire board, which would include the owner's chair.
Is constituted under the executive.
Exactly.
Yes.
Okay, so therefore, a 9-member board requires 5 affirmative votes
Mhm.
for a case.
It would be great if the minutes could reflect that.
Yeah, sure would.
Well, even though there's one absent seat that hasn't been filled,
That's what you were just
that
told.
doesn't make sense to me. Okay. Doesn't make sense to me. Didn't we run this meeting for years with one absent seat?
We ran it for about 10 years with one absent seat. This question has come up repeatedly, and I think at various points, Corp Counsel, that for whatever reason never puts anything in writing, has been consulted, and we actually had a time back in the 1990s when a chairman had a 4-4 tie vote and declared that that meant the motion was defeated. So, but I'm fine, I don't care what the rule is, as long as it's applied
Yeah.
evenly.
Yeah.
And requiring 5 affirmative votes makes sense.
If you think it's important enough, we can hold it over until next meeting and hope that everyone is here. Or, you know, if it is defeated again, we need to have some indication of what we're going to do going forward.
I would like to speak to the substance of the issue, and you cited one case, 333 Park Avenue South, that is where there was a determination made in one direction. I didn't have as much time to do research as I would have liked because I had to be out of town kind of unexpectedly for a portion of the intervening month. But I found a lot of cases that go the other way. And not so long ago, for example, most of us, a year ago, October 26, 2013, in the matter of Ralph Lewis Gherkin, 206-208 Bowery, Gherkin gave evidence of other units that were used, no one applied, and the owners directed the register. It was also had a horizontal multiple dwelling component. Our conclusion, the law board finds that it's a horizontal multiple dwelling. The units located on the second and third floors of the building are covered pursuant to 281.5. Tenant is the protected occupant in the unit. The owners directed to register the buildings and register the 4 residential units, even though there's only one applicant and one unit. And failure to do so is contrary to the law board's rules. And I can give you a few more, and I think with time I could come up with hundreds of them. And from my vantage point, remember, the Loft law is a bit different from either rent control or rent stabilization, in that rent control was attached to the tenant and rent stabilization is attached to the unit. If the unit was used residentially during the window period, I believe the owner is required to register the unit with the Loft board. If the owner then chooses to return the unit to commercial, or to demonstrate that he's already returned the unit to commercial. There's an easy way for the owner to take that unit out of Loftboard coverage. But for us to start saying, oh, here there are instances, many of them, I think dozens and dozens. Another one I found was, that's also relatively recent, is 2010. 5155 West 28th Street, where one of the tenants who no longer, in this case the tenant came and said, I used to live there. She offered proof that she lived there during the window period. She no longer lives there. We found that to be a covered unit and we ordered the owner to register.
Let me just respond to that. With regard to Birkin, I don't remember the specifics on the application, but I can tell you that Villalobos sent her today's calendar. Ms. Villalobos needs the 6 units. She put forth the allegation that there were 6 units that were residentially occupied. The owner was on notice that he had to defend against those 6 units. And I want to say the same thing happened in Birkin. They paid for 3 units or 4 units, whatever it was, and the owner was on notice that the allegations put forth by the applicant were that there were 4 residentially occupied units, and he had to defend against those 4 units.
Well,
But here we're talking about that the tenants, what they did was that they proved that there were 3 residential families living there during the window period to satisfy one of the criteria, which is different than what, sort of what Ms. Villalobos did, which was to pay and to put forth the evidence for those units.
well, wait a minute. We're not in that case yet.
Yeah, I know.
And I don't
It's just an
understand that
example.
case.
But it's just an
So-
example that I think of. I don't remember right now exactly what was in the Birkin and what was done in the application, but it's very likely that if we did that and found that way, it's because the applicant put forth on the application that there were 4 units that were residentially occupied and there were 4 IMD units here. So the owner was on notice.
Okay. And in this case, Metropolitan Avenue, the oath judge, during the proceeding, made a determination that every one of the floors was used residentially during the window period.
That they needed to do in order to make the other 2 the IMD units. If there had been 3 parties to this application that were still in, they would not have had to do any findings with regard to those other units, because they would have had to require the requisite 3 individual families for the purposes of eligibility. So the eligibility finding is one part. Whether it's an IMD and the judge found that they weren't. The judge said, we're only finding these 2 units to be IMDs.
Well, yes, and I think that's an egregious error on the part of the judge.
But I'm just saying that the findings with regard to that unit, one of them, would have been completely superfluous if we had had one other unit where the person had not withdrawn.
Well, it had been my intention, because I appreciate that, to say, oh, what about Gherkin? And now having given you a heads up to take a look at Gherkin, I would, and I had intended to do so, but my schedule this month was not exactly what I thought it would be. I would be more than happy to supply you with any number of cases to take a look at, because I think you'll find the overwhelming preponderance of cases are where we have said these units were proved irrespective of whether or not the occupant of that unit applied or participated. And we've consistently directed the owner to register all the units that were found to be residential during the window period.
There's one thing that still nags at me, Mr. Delaney. Back in the day, the Loft Board very proactively went and brought in as many units as they could, and I have to tell you that I think that was great and the right thing to do. This go-around is sort of different, and here's the thing that gives me pause. We have a lot of buildings still in the application process where there's 1 or 2 applicants to a building. And we say to the other people who have, and this might convince you, to go the other way, but we have many people who say, well, I missed the deadline for filing. And we say, well, unless you're named in this application, there's nothing we can do. You missed the filing deadline, right? Because there's a statute of limitations. Are we going to go and look at all of these buildings going forward and say, well, they're all IMDs and find that way? Or are we going to just stick to the applications that are before the tribunal? I don't know that, I don't have the answer.
I have to say, with all due respect, I don't think that's a question we have to reach in this case.
But that's what you're doing.
Was this case filed before the deadline?
All of the cases that I'm talking about are filed before the deadline. My question is, so in this case, we have two people who withdrew, and you want to find their units or IMDs, even though, by the way, they were compensated for withdrawing. Okay. But now we're going to have all these other people who are going to come down and say, well, I want my unit to be an IMD. But they didn't file their application. And it's not mentioned in the application.
Lenny, isn't that a different question?
It sounds like it's the same question, because if basically if we're going to be covering apartments where there's no application, then
Exactly.
how do you limit those parameters? I mean, that's what this case is about. Right, isn't that, I'm not trying to put words in your mouth, Chuck, but I mean, isn't that the focal point that you think that these are, that there are no, there's no, I don't think there's any factual disputation as to whether they're applications or not. I mean, we're not taking anybody's word for this, right?
And that the oath judge found floors 1 through 6 to have been used residentially.
No, that we have the applications we have, and the applications do not cover all the buildings.
I mean, the ones that are still up. Is that what you're asking?
We're just talking about 140 Metropolitan Avenue.
Right.
What people who haven't come out of the woodwork are going to do, or how we're going to treat them, is outside, I think, the four corners of this case.
Something to do with this.
Well, I don't, all of the floors applied?
All of the floors. It was a six-floor building. Not all of them applied, but all of them we know about.
4.
There were 4 floors. It was 1 floor each. All 6 floors, we know what happened. 1 and 6 are what we're discussing today. 2 of the other 4 withdrew, and 2 never applied. Never applied.
Right.
So there's no dispute. Is that what you were asking? There's no dispute.
Yeah, I'm just checking.
Nobody's coming
So
coming out of the woodwork because it's not residentially occupied anymore.
So therefore, going back to Elliot's question before, the point, the focus is, I think, on what do we do about property where there's no application. That's one of the elements that we're discussing here, right?
I disagree with that interpretation.
Chuck, you had said during our last meeting that you wanted the entire building covered, not merely the ones that had withdrawn. You wanted the building covered for not the ones that had applied, the ones that had applied and withdrawn, and the ones that had never applied at all.
That's correct.
Okay, then I'm missing a subtlety here. It seems to me that we're talking about trying to cover property where there has never ever been an application.
An application is not essential to a finding of coverage. If you read 281.1,
No, just, do you agree or not? If you agree that's fine. I'm just trying to establish what the focal point of this case is. If you're suggesting that I believe what you're saying is, yes, there's no application, but that's not a critical requirement. from your perspective, and therefore an application should not be considered necessary, and that's part of your position regarding this case.
It's not a critical requirement. It's not even a legal requirement. And if you think about it, the mayhem that would be caused, no, if I come in and can prove that all 6 floors, one applicant, nobody else applies, before the deadline, and I can supply proof that all 6 units were used residentially. As I read 281, 281.4, and 281.5, and the Loft Board's regulations, it is the owner's responsibility to register all the units that were found to have been used residentially during the window period. This doesn't leave him trapped, because he can then come in and have as many units as he wants or she wants returned to commercial use, along with signing a 15-year covenant to keep them commercial.
Then I have a question of law. Then what's the deadline for?
Filing an application for coverage or filing a registration application
As the owner.
as the owner.
There's no application for coverage here. They filed an application for coverage for the 1st and the 6th floor units, and I believe the 5th floor unit was withdrew, and the 4th floor unit was withdrew. It just came out in the testimony that they were residentially occupied, the other units, but there's no application. It's not part of the application.
So Chuck, if applications are not necessary, then the deadline is irrelevant?
The deadline is an unfortunate complicating factor that was added to 281.5. I can tell you that if we set the deadline, and I'm not saying therefore we should ignore it, but if you set it aside for a moment to discuss the logic of this, if you take a look, and it's cited in one of our cases, an older case, if you have a building, and let's stick with Metropolitan Avenue, with 6 units, 2 of whom stayed the course and are now, everybody agrees, going to be covered. 2 of whom applied, said, yeah, we live there, we want to be covered, and then for whatever reason, they withdrew. If in fact, owners can now buy tenants out and say, hey, I'll give you X thousand dollars to withdraw your application because I really want to keep it commercial. I don't know why they do that, because they can just return it to commercial. But if I'll give you X thousand dollars to withdraw your application because I want to keep renting it residentially, but I want it to be at market rate, that totally circumvents the purpose of the loft law. The loft law's job is to legalize units that are being used residential. Nowhere does it say, and the only way a unit can be covered is if that tenant applies.
I believe that to convert back to commercial, the owner has to either get an abandonment finding or buy out the rights. Am I wrong? Or an eviction.
Yeah, well,
But so if it's vacant, you can't convert it to commercial until you put in a residential tenant by the map.
unless he bought out the tenants he bought
Well,
out.
but there are 2 tenants that we don't know anything about, who never even applied. For all we know, they just left.
So, I'm sorry, over the years that I've been on board, which obviously is not as long as you Chuck or others, but the idea of tenants settling with the owner to voluntarily leave and therewith withdraw, presumably in exchange for remuneration, has come up repeatedly. I mean, this is a common occurrence. Almost every meeting we've had an approval of somebody, or if not multiple tenants, doing so. And I raised this concern of circumvention of the purpose of the law, and that's why at a certain point, the executive director shared a list, I think, of those properties with other staff in the Department of Buildings. That said, in the years that we've repeatedly approved all of those withdrawals. I don't remember you ever saying these tenants do not have the right to withdraw, or it has no legal bearing on the property. It seems to me you're changing your position, and you would, if I understand, if I'm following correctly, and it would effectively invalidate a huge amount of cases that we've approved, where we said they've withdrawn, tenant says that they're leaving, the owner is okay with this, we can't force them to stay together. It's an annulment.
I think you confused a couple things.
Okay.
The list of buildings that was generated were buildings where applications for coverage by the entire group of applicants were withdrawn. And if you recall, we've recently refused to accept a couple of those because the terms tied to the withdrawal of, well, we'll pretend it's just like the Loft law, and I'll bring the building up to code according to some kind of timetable, where they were setting up a parallel universe, we found unacceptable to public policy. In terms of a tenant who's covered saying, I want to sell my rights, those cases don't come before the board. Those are handled administratively. The landlord buys the rights and either files a 286-12 document right away, or keeps it in his nightstand until he needs to display it. But those cases never come to the board.
The cases that have come before the board in the summer cases that you're referring to, many of them are cases where the tenants and the owners have settled. The tenants have been either for money or not, have agreed to leave. And those units are not made into IMD units, and we just let them go.
Right, so that, isn't that exactly what we have as one component of this case? We've had two withdrawals, right?
Right.
So isn't that precisely the same thing that we've dealt with a zillion times?
I don't think so, no.
I'm not grasping the difference between their withdrawals and many other withdrawals.
Well, let me try to see if I can find something on today's agenda. We had case number 8, where 5153 White Street, where 3 tenants applied for coverage, and the application was withdrawn. Were the tenants able to prove residential use? Were the tenants unable to prove residential use, and their attorney said, you know what, you're not going to win this, it's going to cost you a lot of money? I don't know. Would they have been able to prove residential use, but the landlord said, hey, I'm going to cost you a pound of silver, take a hike? I don't know. But here, this is a different situation, because here, the case has gone to its completion. The oath judge has made 2 findings. One finding is that this tenant's covered on 6, and this tenant's covered on 1. And the other finding that I find critical and relevant is that all these floors were used residentially during the window period. Therefore, from my vantage point, it's incumbent on the board to order the owner to register all the floors and then sort out the process going forward. And I can cite numerous examples where we've done that. And in fairness to people getting a chance to wrap their heads around it, I'm more than happy to supply that list to the board members and to the staff and revisit this next month, because I did not come here to say, oh boy, this is great, I've got a bunch of cases I'm going to spring on Lanny and Martha, and they won't be, and I'll read excerpts and they won't be able to answer.
Well, let me just say that, again, that the chairman, it is her position that she is the one who determines whether a case should be tabled or not. She didn't know that, so I'm going to tell her, it's your determination whether to table this or not. That's okay, how would you know?
We'll get it in the meeting.
So you see, you're learning on the job. So I would suggest that you contemplate that momentarily and make that determination whether you would like to take Mr. Delaney up on his very, very generous offer to give everybody the background of case law, and so that we could really be prepared for this, to vote on this case, which I think is important in so many different directions. Let's see.
So we table it.
Oh, what a good idea.
In fairness to the chairperson, I think, correct me if I'm wrong, but I think our rules also permit a case to be tabled by some voting board members as well.
You know, this is, you had mentioned this before, and, you know, and I think you looked this thing up, but it's not only the prerogative of the chair and Robert's rules.
But we went, for whatever reason, in the 80s, we went out of our way.
We're coming to the same wonderful conclusion.
Yeah, but let's not.
So let's not beat a dead horse.
Let's not.
No offense. Mr. Foggin.
So for the benefit of folks who were not here for this discussion, as I wasn't the first time this case was discussed at the last meeting, how are you planning on capturing
The essence of this?
the essence of the discussion in the minutes?
You know what I'd really like to say to all of those people? Go on YouTube, and you'll be able to see it. And you know, it doesn't take a whole lot of time,
Would that be
because
fine?
you can scroll to just exactly that point and get really the flavor of it, rather than rely on my sort of
So here are the two.
jaundiced way of putting things.
So taking you in all seriousness, here are the two challenges with that, three maybe. One, I don't believe all the video is up.
All of it is up.
Is it all up now?
Absolutely
Okay,
up.
my mistake. Secondly, in reading this in the minutes, one would have to kind of understand that they should direct their attention to this, that there was a rich and interesting discussion with a fair amount of competing points of view.
Mr. Faulkner, I understand that, but if you're the public, you might possibly need to get a prompt from the minutes. But if you're a board member, you know that this has been, and we've had this conversation last month when Ms. Golden Rivera was here, and this month where Ms. Shelton knows that she's missed a very abundant kind of discussion. And I would imagine that they both know that they can capture that if they want to do it. They can capture the tenor and the sense and the language of it much better by going on YouTube and watching that half hour of the conversation than relying on what I'm going to put in the minutes. Not saying that I'm not going to try to put in, you know, as much as I can, because it's an important topic. But I would suggest to anybody that on the board to watch the video. I think that it's important for them to do that. And that's just me. You know, I watch
So
it.
I'd be curious to then poll my colleagues to see what they think, because I feel like
Absolutely.
this has come up before on a couple of different occasions, and it's seemingly not resolved to anyone's full satisfaction.
Well, we're going to try to do better based on your email. We do want to give more of, you know, context, which actually is a word I've adopted now, the staff. Again, regardless of what I put into the minutes, I would certainly recommend to all the board members, if they miss the meeting, and they want to be brought up to speed on any particular
I think that's
event, that they should go and look on YouTube. It is a wonderful source now. And I want to tell you, I work really hard getting those things up on the YouTube, so. Because I don't know how to do it at all. But hopefully, next month, we'll have technical help.
Are you going back to the case, Chuck, or do you want to keep discussing
Just,
context of the minutes?
I do want to spend more on this. Just in terms of how difficult is it, once they're uploaded to YouTube, to get the link on the law?
It's not difficult. I just couldn't do it.
Okay.
Okay? But we're going to have help this time.
Could we,
And they'll be there. All of them will be, the links will show up now.
within a week or so? Was that a reasonable
Yes,
guesstimation?
absolutely, because
Okay,
we,
great.
you know, due to technical difficulties.
Yeah, great. No, that's fine.
No, really, I had it up on YouTube the Monday after the meeting. As a matter of fact, I had it up Sunday, because I did it all weekend. Okay? So, because it's not easy if you're, you know.
And with regard to the question of, the minutes have tended to be, over the last couple of years, almost without any context with regard to the discussion of cases.
No, we don't discuss the cases in the minutes. The minutes never have cases in them. It never has
I think
cases.
that's what your
The
question.
cases do not have the discussion. In the discussion, let me put it this way. The minutes do not have the case discussions.
Why is that?
No, it just hasn't been a
Never, in 30 years, they didn't put them, they did not put, this is, I don't,
It doesn't quasi
Judicial
judicial function,
function.
where, you know, this board right now has opted to do it publicly. But there are other boards, and maybe 10 years, who they don't discuss cases that are brought before it
in the public.
But it's now de facto a matter of public record because it's being recorded, and in fact, you're pointing me to that tool
Yes, but,
to solve the problem that I sometimes feel like I'm the only one that I have, but that has that problem. But so I don't understand why, when there are particularly important discussions happening around a point of policy or a point of that will have relevance for how we would weigh in on other issues, or if there's follow-up that comes from the discussion, why that couldn't be captured
I think that,
meaningfully in the minutes.
I think that, just from a legal standpoint, I would have imagined that in the past, the board and the general counsel of the board basically had determined that they did not want the discussion of the board to be in, and they used to do a pretty detailed reporting.
I
And
understand
they
that may have
didn't
been the
want it
case
to
in
be
the past, but it's not the case now.
exhibit one.
It's not the case now, and so it's,
Well,
I think
it
it's a
is
move
because
back.
you still have to pay, you have to pay somebody to transcribe it. And it has to be done by a you know, just like our case. We always take.
I don't need a transcription. I'm suggesting
I'm not talking
a
to
summary of the discussion
Yeah.
points.
May I say something about this? I've had a couple of occasions where I chaired a conference, and I looked at this thing on video sometime after it. And at the time, everybody there was, you know, into what was going on, and we all thought it was great. And then I watched it on video, and I thought it was incredibly boring. And that is because there's so much discussion that goes on in these meetings and stuff that are partially irrelevant. That is why I would say that some kind of judicious summary of what goes on that we could read in 5 minutes rather than looking at 35 or 40 minutes of videotape.
I second that. I wish there were a motion.
Again, from a legal standpoint, I do not think that putting a discussion for discussion of the cases, anything else, yes, but of the cases in the minutes. And what I was saying, Mr. Fogden, was not about you, but about any follow-up Article 78 that comes out of this. When somebody wanted to take this on, they needed to get the tape. We always tape everything and put it on a cassette. They would have to take the cassette, copy it, and get a stenographer to do this, to put it in a record for an appeal. I don't want the minutes, which are not transcribed and are not
So I'm sorry, is the
word
argument
for
behind
word.
that you want to make it harder for people to bring in Article 78?
No, I want the summary of a case not to be used as part of evidence, because it is not evidence, and I don't want it to be misused. Do you understand what I'm saying, Martha? If I do a subjective, or I even try to make an objective report of what you said with regard to a debate on the cases, which is a judicial This is the judicial part of what you do. And I put that in the minutes. I'm not trying to make it difficult for anybody to do an Article 78, at all. But if you have that and you want to use, and some lawyer who's not very good might put this in as evidence of what the board said, and it is not what the board said, okay? It doesn't belong in the public domain. Now, if they want to put the videotape in, that's a word-for-word rendition of what the board said. That is accurate, that belongs. If that's what the person needs to do, that's what they can do. That's a word-for-word, whether you put in the video or you put in the transcription by a stenographer that's certified. But this should not be, and this would be, and I don't want to do that.
The only issue were that we did not capture the nature of the discussions that we have around cases, but we did everything else. I think we could have that separate discussion on the merits. But I'd like to make a point, maybe it's a motion to make after some more discussion, that where it matters less perhaps on the non-case discussions, that we include much more detail.
Absolutely. Mr. Fogger, you don't have to take a vote, because as I said, after I read your email, and also Mr. Delaney has weighed in on this, I'm perfectly, willing to put more context in and more information, just not in the cases. Everything else, all of the other discussion, policy, all of the other stuff, no problem.
Can I ask, first of all, I agree that more detail would be better to the extent that it's possible. Secondly, I think in fairness to the fact we've been kind of shifting from foot to foot, waiting for new leadership, it's fair to give the chairperson a chance to discuss this with the staff. But I would ask, and I don't know if I feel strongly one way or the other, if at last month's meeting I had said, I want the record to reflect that I think if an oath judge finds residential use during the window period for all units that a judge or hearing officer finds residential use during the window period, those units must be registered with the Loft Board, and I want the minutes to reflect that. Would that request be honored?
I don't think so.
Pardon?
I don't think so. If it was part of the discussion of the cases, do not put that in. For that specific reason.
Well, the thing is, I don't see the terrible distinction between that and the fact that it's now videotaped. And when that law came down, I started to think, gee, maybe I ought to watch what I say sometimes, because I tend to be, try to make jokes, which is maybe not so good, and I don't want some lawyer for either side to say, look, if so-and-so is doing this, and he's ruining the record, and one thing or another. But, now that it's all public, everything that we say can be construed by anybody, and we could more readily be sued by some lawyer because of the ongoing discussion that goes on here, because now it's open to the public. So I don't think there's a whole lot of big difference between whether it's transcribed partially, on paper, or whether it's on YouTube or whatever.
Mr. Delaney, in response to your question, when you want to go on the record, you always do. You write a dissenting opinion, you write a concurring opinion with your own words, and that you made part of the case, the opinion of the case. So it's not like you're being deprived of being able to say, this is what I feel, and I want to be on the record, because you do go on the record, and you do that.
Well,
so anybody can do that.
And as I said, I'm posing the question, and I don't know what I think the answer should be. But, and believe me, I'm well aware that one has the opportunity to provide an opinion.
So all I'm saying is that my concern, Mr. Shackley, thank you for your service. All I'm saying is that when you put something in the legal, that is part of our quasi-judicial function. You need to either have the transcript, have it transcribed, or have it be on the video. My summary is not, or any of our summary, is not really going to give the fair and accurate description. It is a dangerous way to go, and I would prefer not to do that. However, I will certainly, yes, I don't think, do we have enough people? 1, 2, 3, 4, 5, we just made it. Okay, for the last case. So so I will endeavor to have us do better in doing the other part of the minutes. All right?
Now, I'm sorry, but I do have one more question.
Mr. Delaney, you are just giving me so much stimulation.
The camera's rolling.
What can I do?
Just move on to the executive director. The question that you raised, and maybe I would just ask that the staff think about this. The notion that there was there's some danger of an unfairness to the owner because he did not know he had to defend against other units. That's an argument that I haven't heard really articulated quite that way. And if the owner's represented and proofs are being offered for all these floors and the judge is saying, yeah, look, 2, sounds like the proof, you know, I'd like a little more clarity on whether that's, whether there's a valid issue there.
We're saying that he doesn't know that that he has to defend it, right? I mean, he's there and he knows that he has to defend 2. And in this particular case, I think he conceded that, yes, it had been residentially occupied. I don't know if he conceded to everything else or if he wanted to. Or having bought out everybody else, that he thought it was an issue that he was going to have his units made IMDs. Perhaps, I would imagine that he thought that was over, that he had taken care of that. So he didn't, so, I mean, Mr. Shapiro, who was the attorney, was very, he was doing his SRO defense and he was doing, he was doing all of that, and I am certain that he would have done the same thing for the other units. And he did not. Why didn't he? Well, because there was an issue. Did he just say, oh yeah, they're IMDs too? No.
Okay.
You got it?
I hear it. I don't buy it, but I hear it.
Did you buy it? I said, did you get what I'm saying? I know you don't.
Yeah.
But that is something to consider, that you saw how the owner's counsel defended so avidly against having these 2 units be IMDs, yet there was nothing said about the other ones. Had he been on notice that that was an issue, you can bet that he would have created some defense, whether it was the same defense or not. I don't know how they were being utilized. But there was nothing. There was no defense. How can you do that? So we'll take it up again next month. So let's go to Ms. Villalobroda and her case. So that, I'll not just do this. The third master case is a coverage case as well. It's Anna Villalobroda. I'm doing that because I've been practicing. 155 Suffolk Street, TR 1020. Ms. Cruz, would you please present this coverage case?
On August 6, 2012, Anna Villalobroda, a shareholder for the 4th floor rear unit and the 5th floor unit at 155 Suffolk Street, filed an application seeking Article 7C coverage pursuant to 281.1 for 6 units. The applicant later amended her application to seek coverage for the 4th floor rear unit under 281.5 and not 281. During the course of the case, the owner conceded that the 3rd and the 5th floor units were residentially occupied during the labor period. On February 12, 2014, Judge Bruna issued a memorandum decision in which he found that the 2nd floor unit was covered under Article 7C, based on the principles of res judicata and collateral estoppel. Judge Spooner relied on a prior decision from Justice Steinman in an unrelated dispute to find that the second floor unit had been residentially occupied during the window period. Regarding the fourth floor rear unit, Judge Spooner set the issue down for a hearing. In his report after the hearing, Judge Spooner found that the second, third, and fifth floor units were covered under 281.1, and that the fourth floor rear unit was covered under 281.5 as an included unit. There was no determination with respect to the other two units seeking coverage. The Loft Board has applied doctrines of res judicata and collateral estoppel in cases when a court of concurrent jurisdiction already decided the issue in dispute. However, Justice Steinman did not decide the issue of Article 7C coverage. In finding that the building was a de facto multiple dwelling, Judge Diamond stated that the building had been occupied by 3 or more individuals since 1974. However, finding that the building is a de facto multiple dwelling is not a finding that the building meets the specific eligibility criteria for Article 7C coverage. Justice Diamond did not make specific findings about residential occupancy during the window period, and she did not decide the issue of Article 7C coverage. Staff recommends that the board reject Judge Spooner's recommendation that the second floor is an IND based on Judge Diamond's decision. We recommend that the board amend the matter back to oath for further proceedings. The staff also recommends that the board reject Judge Spooner's findings about the fourth floor unit at this time because Article 7C coverage for the fourth floor rear unit is contingent on the finding that the building is an IND, and there is no finding. There can be no finding about coverage under 281.5 for the fourth floor at this time. The staff also recommends that the board direct Judge Spooner to make findings about the Article 7C claims for the other two units on the application.
Does anyone have any questions or comments about this case?
Mr. Delaney.
I'd be happy to yield to any of my colleagues. What is it that we're seeking to do here? We're sending it back to Judge Spooner.
We're sending it back to Judge Spooner.
And we're not making any findings
None whatsoever.
other than
That's res judicata did not apply.
that he can't base his decision on res judicata.
Exactly.
The fourth floor rear unit, which is point 2 in the second to last paragraph or the first paragraph on page 3. Thus, there can be no finding at this time as to whether this unit is eligible for coverage under 281.5 as an accreted unit. How would you apply the accreted unit doctrine to a building covered under 281.5?
The building would be covered under 281.5. It would be covered under 281.1. She was seeking coverage under 281.1, and she was seeking coverage for 281 for the fourth floor.
Okay, okay, right. So that sentence might need a little
Tweak?
tender loving care.
Which sentence? The one that starts Article 7C?
No, your first paragraph, page 3, the last sentence, thus. Thus, there can be no findings whether this unit is eligible for coverage under 281.5 as an accreted unit.
Okay, so we'll make that, no, I think you mean that we should put in the 281.1.
While it is
building.
possible that it
Yes.
could be demonstrated
Right.
that,
Okay,
yeah, just,
will do.
yeah, I thought, wow,
Okay.
how did I miss that? I'm also, there's a little, the fourth floor rear unit came up later. And in the first paragraph under background, we talk about the fifth floor front unit and the fifth floor rear unit. But then it seems to just talk about a fifth floor unit.
Exactly. So we have asked in the last paragraph for Judge Spooner to please tell us whether they're, because Ms. Villalobroda
Right, okay,
in her
fine.
application put in all those units,
Fine.
but then during the entire report and recommendation, it's just the fifth floor.
Right.
So we are unclear as to what happened with those, so we would like to have clarification from Judge Spooner.
Yeah, I'm worried about that.
Okay.
So be it. Okay.
Any other comments, questions?
Do we have a motion? Mr. Vaughan, do we have a second? Ms. Kurtzman? Ms. Weld, would you please hold the board?
Mr. Barowitz,
Yes.
Ms. Kurtzman,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Foggen,
Yes.
5 in favor, 3 absent.
It carries. Just so you know, Ms. Villalobroda is right there. And, you know, she was a little concerned herself because she didn't understand that we were just remanding it back for fact finding. Now she understands. So now we're going to, I'm going to ask the chairperson if she would mind tabling the legislative discussion so that we can have the full board, unless you have something that you want to add.
I was wondering if you wanted to do the last 2 cases. on
Oh
the
my
agenda.
goodness, I forgot the last 2 cases. Last 2 cases are removal cases. They are voted on as a group. Do we have a motion to accept those cases? Mr. Fogg, a second. Mr. Barowitz, can we hold the board, please?
Mr. Barowitz,
Yes.
Ms. Kurtzman,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Foggen,
Yes.
5 in favor, 3 absent.
Does anybody mind if we table the legislative discussion?
Um,
We're all here.
I think Mr. Shacker would be very upset in this.
I do too. But,
My only question was, last month you had a sense of urgency on the part of the city's lobbying team.
they've not contacted me yet.
What was
We
the
have
reason?
received it. So it seems that we have some time. And I'd like to be able to bring the chairperson more up to speed on what everything says and means.
I have no objection.
Table that discussion for the next time.
Okay, so moving to the end of
This will conclude our,
that's it.
this will conclude our October 24th, 2014 Loft Board public meeting. Our next public meeting will be here in Spector Hall, 22 Reed Street,